Good evening, everybody. Welcome to all the participants. Firstly, I must thank all of you all for joining this very interesting webinar that we are having today on a very important topic. This Maharashtra Stamp Duty Ordinance of 14th October 2024 on the stamping of arbitral awards. When I first read it, it seemed simple at first blush. But then when I started looking at it in greater detail of its impact and what it would entail, I found that it's a very complex issue and will greatly affect all stakeholders, arbitrators, parties, lawyers in arbitration. It has too many questions and is not as simple as going ahead and just paying the stamp duty on the arbitral award. Our speakers today, let me assure you, have done a lot of hard work on this, and they're going to deal with this subject and its complexities that may arise and be faced by people in arbitration. One more thing I would like to point out, that our earlier two webinars on evidence as well as one on the arbitration bar are already on YouTube, and so will this find its way on YouTube subsequently. I must thank my committee members, co-chairman Bhavesh Panjwani, the head of the subcommittee for webinars, senior advocate, Supreme Court, Shikil Suri, Neha Feni, Raj Panchmatia, Vyom Shah, and various other committee members who are present today on this, like Rakesh Mandavkar, and I don't know who else is there, but I hope they will be there in strong numbers. The other thing I wanted to point out, that IMC and its arbitration committee is conducting these webinars. In fact, we are going to continue with the series on evidence a little later. The purpose of this webinars is to educate people, to discuss topics which are important in arbitration, in respect of which there might be some doubts, some complexities, so that people can get a better hang of it and the practice of arbitration improves. The other thing is that, as many of you all might be aware, we conduct a 7-day course on arbitration. The next one is scheduled in March 2025. I would request those who have not done it, please do it. It will benefit you. It's open not only to lawyers, but everybody who is interested or practicing in arbitration. Apart from that, the arbitration committee also sends a lot of representations to the government on various aspects. Like recently, we sent a representation on the 2024 proposed amendments to the Arbitration Act, and we intend sending a representation on this stamp ordinance. Let me introduce our speakers for today. Let me start with our committee member, Anand Shende. Mr. Shende started his practice with short stints with senior advocate Mr. M.V. Paranjpe, who was the former Advocate General of Maharashtra, senior solicitor and partner of Mulla and Mulla, Krigi, Blunt and Kero, Mr. D.M. Popat, senior advocate, Supreme Court of India, Mr. Tentan Andhyarujina, who also was a former Advocate General. Anant worked as a legal executive for nearly 2 years with the Walchen Group and exclusively for Hindustan Construction Company Limited, what is popularly known as HCC, for 1 year. Thereafter, he joined and settled down in the chambers of senior advocate Mr. Rohit Kapadia before starting and setting up his own independent practice. Anant, I would say, can be said to be a pioneering member of the arbitration bar, with few others in Mumbai and India. Since 1992, that is almost for 32 years, he has almost worked exclusively as arbitration counsel and in few cases as an arbitrator. He says he has lost count of the number of arbitrations and the varied subjects he has handled in the past 32 years, and I would believe him because he doesn't. I don't think Anant even possesses a black coat because he's all the time in arbitrations. Is closely connected with the subject of today's webinar, being a subject on which he is frequently called upon to advise. Anant, as I mentioned earlier, is an active member of IMC's arbitration committee for over a decade. He also delivers lectures in the 7-day arbitration course and participates in making representations on issues relating to arbitration. Anant is going to be the speaker and the moderator for today's session. His co-speaker is another eminent personality and a known person in the profession, Mr. Nilesh R. Modi. Nilesh is BCom LLB and is an advocate solicitor. His firm is Rustamji and Jinwala, advocates and solicitors. Nilesh passed his LLB in 1988 and became a solicitor in 1989 and has been in active practice since then. He has an experience of 35 years in the profession in diverse and varied fields in law. Rustamji Jinwala, his firm was incorporated in the year 1914 and way before independence and is now a 110-year-old law firm. Nilesh himself is a third-generation solicitor and advocate, both his father and grandfather being in the same profession, and more notably, in that same firm of Rustamji Jinwala. Nilesh has been very active with the solicitors group. He has been the honorary secretary of Bombay Law Incorporated Society, what is popularly known as BILS, an association of solicitors. He has been its secretary for the past 6 years, and BILS is a Section 8 company. Apart from this, Nilesh has a very philanthropic and humane angle to himself, to his personality. He is a trustee in very many charitable organizations, including Shanti Avedna Sadan, Bhadra New High School, K. Munshi Yojana, A.K. Munshi Yojana Trust, Dhanji Bhimji Matani Charitable Trust, Lakhani Foundation, Geet Sangeet Sagar Trust, Girdali Lal Chawda Charitable Trust, amongst the many, very many. Also, very importantly, which I have noted, he is a member and an active member on the board of National Burns Center, Indian Burns Research Society. He is also closely associated with Ashima Charitable Trust. With this, over to you, Anand, and to all participants, keep your questions ready. You can put your questions in the chat, and later on they will be taken up, provided time permitting. Go ahead, Anand. Over to you.
Thank you, Gautam. I'll thank you on behalf of both of us for a lovely introduction, though a little longish, since two speakers were to be introduced. Gautam mentioned that we have put in a lot of hard work. I hope that we have also worked smartly and not just done hard work. This amendment, as he said, was carried out recently on 14th October 2024. And the amendment, so far as arbitration is concerned, increases the stamp duty on the arbitration agreement from 100 rupees to 500 rupees. And more importantly, the stamp duty on the award is also changed. Earlier it was 500 rupees flat. Now it has been changed. For immovable property, it will carry the same stamp duty as a conveyance. And for movable property, awards relating to movable property, now the stamp duty has been made ad valorem. The moment it is made ad valorem, the quantum of the duty does increase. But more importantly, from arbitration point of view, it does create possibilities of blockages. It does create possibilities of delays, or it does create risk to the participants if the duty is not paid in time, about paying penalty, etc. We have recently seen, I mean, these are little general comments with a bit of digression, that arbitration has been going through some turbulent weather. Arbitration Act of 1940, as you know, was amended in 1996, but thereafter has already undergone 3 amendments and one more is in the offing. On the one hand, government is showing that it is very keen on expediting arbitrations, but on the other hand, government has issued a policy decision advising every government organization and PSU to delete arbitration clauses from their contracts. Now, arbitration, as we know, has 2 points. One is the entry point when the arbitration commences, and the exit point, which is the award. At one time, there was a serious problem with regard even to the entry point, because arbitration commences with the appointment of the tribunal, either directly by the parties or through the court. A doubt started arising whether when the court is approached under Section 11 and it is discovered that the main document, proper stamp duty, has not been paid, or stamp duty on arbitration agreement has not been paid, the question arose whether Section 11 appointment should be held up and arbitrators should be appointed only after the stamp duty proper has been paid. Luckily for the people who are in arbitration, NN Global case sorted that out and said that no, the matter need not be held up in Section 11, but can be proceeded with by appointing arbitrators, and it will be for the tribunal to ensure that proper stamp duty is paid on the main document as well as arbitration agreement, which is normally contained as a clause in the contract. So therefore, today when we are discussing the exit point of arbitration, which is the award, it is assumed that stamp duty on the main document as well as the document containing arbitration agreement has been resolved and sorted out. Now, when we talk about the exit point, with this revision that has happened recently, see, till now with 500 rupees as the stamp duty, nobody even thought about the stamp duty aspect at all. Normally, in any arbitration, the arbitrators would direct both the parties that please deposit with me 2 stamp papers of 500 rupees. He would make his award, sign it, declare it, and distribute it to the parties. It was that simple. Now, with this ad valorem duty, things have really become difficult because it is now necessary to decide who has the responsibility to pay the stamp duty. And it is also necessary now to know when it is to be paid. Because if the stamp duty amount is large and it is not paid in time, there is always a risk of penalty, which can be as high as 4 times the duty amount, as Mr. Modi will explain to you a little later. This risk is definitely there, so the party not only has to pay the stamp duty, but for causing delay in payment, the party may have to pay penalty as well. So the question that arises is, who has a duty to pay? Now, as per the Stamp Act, as sort of we learned, because as arbitration counsels, we never bothered about stamp duty, frankly. We knew that 500 rupees stamp paper is good enough. But for the first time, we had to look into the, at least the cursory provisions of the Stamp Act. And what we realized was that the Stamp Act says that whoever, now in this particular case, the arbitrator, who is executing the award, must pay stamp duty either before executing it, or on the day he executes it, or on the next day, next working day, immediately following the execution of the award. Now that shows when stamp duty ought to be paid on an award. The question is arbitrator required to pay? Because if he doesn't pay that, there are very stringent provisions under the Stamp Act, including talking about a guilty party who does not pay stamp duty knowing that he is evading the stamp duty, being sent to the prison for not paying the stamp duty on time. So therefore, if the arbitrator has to pay, it is a bit dangerous, because suppose there is a stamp duty which is payable, let's say running into 5 lakhs of rupees. What does the arbitrator do? Does he pay from his own pocket 5 lakhs and then executes the award? Or would he be entitled to ask the parties to pay it, or ask the parties to deposit that sum with him? Now the problem with this, because of ad valorem duty, by reverse arithmetic, the moment you say that please send me 5 lakhs towards stamp duty, it is easily possible to know what is the quantum of the award that the arbitrator is going to give, which is something which no arbitrator would like to do, as we know that they do not want to disclose their mind, which is right. The award should be kept confidential till the last minute. In which case, what is to be done in such situations? Because today, after 14th October, there must have been awards which have been declared already. There will be awards which will be in the process of being declared. Now, what is to happen in all those cases where award is already declared and probably stamp duty has not been paid because this amendment has come all of a sudden, it is applicable immediately and it is prospective. So therefore, any award which has been declared after 14th October, on that award, proper stamp duty should have been paid. Now, section 30. Sia, can we see section 30 on the screen, please? Of Stamp Act.
Okay, sir.
30.
Yeah.
Section 30 deals with the subject who should be paying the stamp duty.
Articles, it's above.
No, you've gone to schedules here, not this main part of the act. The first
Okay.
part where sections are given.
Sure,
Yeah,
sure.
there.
I don't know, somehow I'm
Forget it. Please allow me to read it from the book. If you can put it on the screen, nothing like it. Section 30, the title is Duties by Whom Payable. It begins with the qualification, and this is very, very important. I'll come back to it. In the absence of an agreement to the contrary, please remember this. But after that, it says the expense of providing the proper stamp shall be borne. Then it lists various articles under the Schedule 1. And there is a residuary article at the end.
From press any key, charges ₹39 for 30 days.
In any other case by the person executing the instrument. So by this process, it becomes very clear that under 30, it is the arbitrator who has to pay the stamp duty, who has to bear the expense of providing the stamp duty. But this particular section begins with the word in the absence of an agreement to the contrary. And that, I think, is what perhaps would save an arbitrator from committing a default of section 30. Because every arbitration agreement, there is a provision, and even there is a provision under the Arbitration and Conciliation Act regarding the costs. We'll have a look at those as well, where costs of an arbitration are within the discretion of the arbitral tribunal. And the arbitral tribunal can decide who will pay the cost of arbitration. Then the next question that has to be answered is, can the stamp duty be considered as cost of arbitration? Now, there are two good indicators within the Stamp Act. One is section 30, subsection F. Since we are unable to share it on the screen, I will read it out. I'm reading the same section 30, subsection F. In the case of an instrument of partition by the parties thereto. Now, this is saying who is to pay the expense of providing the proper stamp. In the case of an instrument of partition by the parties thereto in proportion of their respective shares in the whole property partition, or when the partition is made in execution of an order passed by the revenue authority or civil court, or now this word is important, it says arbitrator. In such proportion as such authority, court or arbitrator directs. So therefore, arbitrator is expressly given the power to say which party before the arbitrator shall bear the expense of the stamp duty. There is another section 43 of the Stamp Act. The 43, the title is persons paying duty or penalty may recover same in certain cases. Subsection 3 of section 43 says this: such amount may, if the court thinks fit, be included in any order as to, again, the important word, costs in any such suit or proceedings to which such persons are parties and in which instrument has been tendered in evidence. If the court does not, for the reasons to be recorded in writing, include the amount in such order, no further proceedings for the recovery of the amount shall be maintained. So 43.3 expressly treats stamp duty as cost about which the court can make an order. So therefore, these two sections do seem to suggest that stamp duty can be definitely considered as cost in any litigation, and it need not be a separate cause of action. Because any claimant in any of his statement of claim, and when I say claimant, I also include counterclaimant, there is always a prayer for costs. Now, the difficulty in cases where arbitrations are pending and award is yet to be made, the parties would like to know whether they can ask the arbitrator to indicate in his award as to which party will pay costs of the stamp duty and in what proportion. Now, there also, if you go to section 31 of the Arbitration Act, Arbitration and Conciliation Act, and I'm referring straight to 31(8). 31 deals with form and contents of arbitral award. Subsection 8 says, Sia, you'll be able to get this on screen?
Yes, sir.
Yeah, 31(8).
Just 2 minutes, sir.
Have you got it? I can't see it very clearly. 31(8) says,
So we can
the
see.
cost of
31
you can see
A, 31. 31,
31,
please.
31. 31A
31
later.
8.
31
8. Yes, after
Subsection
7,
8.
next page, page 20. Yes, this one, the last one.
The costs of an arbitration shall be fixed by the arbitral tribunal in accordance with section 31A. So when you go to 31A, it deals with regime for costs. In relation to any arbitration proceeding or a proceeding under any of the provisions of this act pertaining to the arbitration, the court of arbitral tribunal, notwithstanding anything contained in the code of civil procedure, shall have the discretion to determine whether costs are payable by one party to another, the amount of such costs, and when such costs are to be paid. For the purpose of this subsection, costs means reasonable costs relating to the fees and expenses of the arbitrators, courts and witnesses, legal fees and expenses, any administration fees of the institution supervising the arbitration, and there is a very broad general explanation, any other expenses incurred in connection with the arbitral or court proceedings and the arbitral award. Therefore, taking recourse to 31A regime for costs and 31(8), and if stamp duty is to be considered as cost, as seemed to be indicated by the Stamp Act itself, I am of the view that it should be possible for the arbitrators now to award stamp duty component also as cost to be paid as part of the award. So a successful party can be awarded the ad valorem duty of stamp that will be paid by the unsuccessful party against whom the award has been made. But this the stamp duty must be paid, as we have seen, when the arbitrator has already executed the award. Within how much time the successful party, because once the award is delivered to the parties, the successful party knows that it has succeeded in getting an award in its favor, directing the unsuccessful party to pay the stamp duty costs. It should be possible for them or embolden him to pay the cost, the stamp duty, And of course, he knows that he's going to recover it as part of the award. Now, that is where we will be now shifting our attention to the Stamp Duty Act, that when this successful party should pay the stamp duty, should he pay it immediately? Because as you all know, an award is not the end of the arbitration by itself. There is the possibility of it being challenged under 34. Then, of course, there is an appeal under 37. There is now a special leave petition which can be taken up after 37. And now we have seen in the MRC's case, a curative petition set aside the award after more than a period of 1 year. So the question is whether a successful party would be willing to pay the duty, stamp duty. Suppose it's a very large duty. For example, the DMRC award was something like 2,700 crores. Now on that itself, the stamp duty, as we calculated, would come to nearly 7 crores of rupees. Now, having paid 6-7 crore rupees, and at the end of the day, if the award is set aside, what happens? Does he lose all that 7 crore rupees, or can he claim? Now, these are the issues which are troubling all those who are stakeholders in any arbitration. And therefore, I'm going to now hand over the further proceedings to Mr. Modi, starting with an opening question first, that whether the party should pay immediately once he knows that stamp duty is payable, or can he wait till the outcome of 34, 37 and SLP is known and then pay once he knows that the award is enforceable? And if he chooses to wait, does he expose himself to the question of penalty? But prior to that, under 34 and 36, suppose he has not paid the duty, then what will happen the moment the award is sought to be admitted in evidence under section 34, or if when you go for enforcement under 36, it is bound to be impounded by the court. So as generally, for general knowledge also, we would like to know what is this process of impounding? How long does it take for a document from being impounded in time to the time the stamp duty payable on it is paid, at least in Bombay? I mean, Maharashtra, of course, is very large and time taken would be different. But in Mumbai, what is the time usually taken for adjudication of the stamp duty? And thereafter, please take us through when the stamp duty should be paid to avoid penalty, or even if payment is delayed pending the outcome of 34, 37 and all that, no penalty would be attracted. Please.
Good afternoon, everyone. First of all, let me thank the IMC and the Arbitration Committee for giving me this opportunity to be here today, and particularly Mr. Shinde and Gautam. And thank you all for joining in today. Now, as my colleague here, Mr. Shinde, has pointed out, once an award is passed, now the ordinance which is come and is effective from 14th October 24, stamp duty is attracted on the award itself. Earlier, that stamp duty was just 500. Now, for immovable property, stamp duty as for an conveyance under Article 25B, and for movables or for money claims, it is based on ad valorem duty. First, we'll look at the ordinance for a moment. If we see the ordinance, the first part of the ordinance, here, can we have that ordinance
Yes, sir.
on screen? The ordinance deals with a lot of amendment in the Stamp Act and increase in the stamp value for many articles, but we will today restrict it only to the award. So we'll go to that amendment for award in the ordinance.
I'll start reading just to save time. So the first part of the article for award has remained the same, and that is that what is an award? Award, that is to say, any decision in writing by an arbitrator or umpire on a reference made otherwise than by an order of the court in the course of a suit, being an award made as a result of a written agreement to submit present or future differences to arbitration, but not being an award directing partition. Now, these words have remained the same, which was earlier. So, what this ordinance brings in is only the amount or the value or the quantity to be paid towards stamp duty. Otherwise, there is no change in the wordings here. So from this first part, it clearly shows that award is something which is passed by an arbitrator or umpire on the basis of a written agreement to refer the disputes to arbitration. Therefore, the arbitrator is basically a quasi-judicial authority deciding a dispute between two parties, and is in the same position as a court deciding issues. Now, what they have excluded from this from the beginning is that if reference is made to an arbitrator from a suit which is filed in the court, then this particular article doesn't apply at all. And same way, there is another exception, which is that if there is a partition, award which gives a partition, then again there is no duty payable. So these two exceptions, there is no duty payable, but for the others, it is payable. Now coming to chargeability section, the charging of stamp duty is on instruments. That is under section 3 of the Stamp Act. And instrument is defined under section 2LA of the Stamp Act, and it says 2L. Instrument includes every document by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. And then it says, but does not include other things. Now, there is no award in this, but basically, we have award would create any right or liability, or creates, transfers, limits, extends, extinguishes, or records any such right or liability. Considering that, yes, when an award is given in favor of one party or the other, there is a right created or there is a liability created, the award becomes stampable. And therefore, there is a specific article in the Stamp Act to pay stamp duty on awards. Now, as my colleague had addressed you on section 30G, that the executant of the document or instrument is liable to pay stamp duty when there is no specific reference in the other provisions in section 30. Then obviously, as an executant, would it be the responsibility of the arbitrator to pay that? My answer to that is no. Basically, twofold reasons. One is that, as I've read it and as he has also read it, that once an arbitrator is appointed, he is deciding a dispute. So he is not a party to the document inter vivos. It is not an instrument inter vivos where two parties are agreeing and therefore the executant of that document needs to be paid. He is a person who is deciding the dispute between the parties. He is in a situation where he is a quasi-judicial authority taking a decision. So therefore, the intention of payment of stamp duty and hoisting liability on the arbitrator, in my view, would not arise. That would not be the intention of the legislature in doing so. Second thing, if you see the first part of section 30, it says, in the absence of an agreement to the contrary. Therefore, normally in arbitrations, when arbitration commences, directions are given, parties are made to know that how the costs of the arbitration will be paid, how the arbitration proceedings will proceed. In that, if it is recorded that yes, there is an agreement that the cost will be borne out in a particular manner or as per the arbitrator's award. And since Mr. Shinde has also pointed out to you that this amounts to cost. Therefore, if it is a cost and an agreement has been arrived at for payment of such costs, then obviously when there is an agreement to the contrary, there would not be a situation where the arbitrator as an executant of the award will have to pay any stamp duty. Therefore, the liability of arbitrator to pay stamp duty would be minimized to that extent. Now, the time when that stamp duty is to be paid, under section 17 of the Stamp Act, it is provided that a document which is executed in the state. I'll read section 17. Can you go to section 17? See, in the Stamp Act itself.
See, yeah,
So
section,
instrument 17.
section 17. You were at the right section earlier, please.
17.
That's right. Can you magnify it?
Yeah. So it says instruments executed in state. All instruments chargeable with duty and executed by any person in this state shall be stamped before or at the time of execution or immediately thereafter, or on the next working day following the day of execution. According to this, if the award is passed in the state, then once it is executed, you can give it for stamping. You can stamp it either before it is executed or at the time when it is executed or even one day later. So the fear that the arbitrator will have that I'll have to disclose if I call for cost earlier can be evited by saying that I am declaring this award today by signing it, executing it, and telling the parties, directing them that you can present it tomorrow and pay the stamp duty on that. Stamp duty is now payable online. So they actually don't have to go and give the award also to the stamp office. All that they have to see the award, calculate it, and whoever has been directed can just pay it online and get a challan and attach it to the award.
Is there some grace period available for payment if it is not paid immediately next
No,
day?
that I will come to that later. Grace period. Before that, let me just complete on section 18, which is the next section, where the instrument or the award is signed out of state. Now, there may be situations where arbitration awards, the seat is outside the state of Maharashtra and it is signed outside the state of Maharashtra. In such a case, if that award is brought into the state for execution or for challenge or whatever reason, once it comes back into the state, then it has to be stamped within 3 months. That is what section 18 provides, that every instrument chargeable with duty executed only out of this state may be stamped within 3 months after it has been first received in the state. So therefore, if the seat is outside and once it comes into the state, you get 3 months time. So that is the grace period there. Also, there is one more provision in the Stamp Act That is section 31, which provides for adjudication. If the stamp duty is not paid on the award and party is directed to pay, they have 30 days to submit that document for adjudication under section 31. Can we have 31? One 31. Yeah. So this is for adjudication. When an instrument, whether executed or not, and whether previously stamped or not, is brought to the collector by one of the parties to the instrument, and such person applies to have the opinion of the officer as to the duty, if any, with which or the article of schedule 1 under which it is chargeable, and pay a fee of 100 rupees, the collector shall determine the duty, if any, with which or article of schedule 1 under which in his judgment the instrument is chargeable. For this purpose, collector may require to be furnished documents. That is all right. We can skip that. And the time which is required mentioned in this is 30 days. That is under subsection 4, where an instrument is brought to the collector for adjudication within 1 month of execution or first execution of such instrument in the state. So this gives 30 days and 1 month's time for you to submit it for adjudication. And if it is executed outside the state, again it is 3 months. And thereafter, the time of 60 days is given to pay the stamp duty once a demand notice is issued. In such a case, the penalty is charged only if you fail to pay within 60 days of the demand notice being issued. So this is one more situation where you have a time to submit the document. Now, once it is submitted for adjudication, normal time taken is about 30 days. Depending on where it is submitted, there are chances where the collector doesn't give or issue a demand notice immediately. It takes time. For example, under the amnesty scheme, a lot of people have submitted their documents, but demand notices are yet coming because there's a lot of delay in that. And there's a lot of backlog in that. So I am told that even a lot of awards are given for adjudication, but it is still pending. Once it is submitted in time, and if the demand notice has not come, there won't be any penalty because you get 60 days to pay the amount after you receive the demand notice. So therefore, till that time, the document will remain.
So practical advice for you is of yours is submit the
Submit it
document
for
for
adjudication.
adjudication, and normally it
Yes.
should take some time, by which section 34, if it is to be filed, will have been filed.
Yes.
Right.
Now,
Now impounding, you know.
yes, that's what I'm saying. Now we come to a situation where the party in whose favor award is passed would like to execute and get the fruits of the award. And it is also possible that the party against whom the award is passed would like to challenge it under 34 and also seek a stay under 36(2). In such a case, that party will file a petition or an execution application in the court, High Court, for us. And once that is submitted to the High Court, the court will have to see and impound the document or direct an officer of the court to impound it if it finds that the stamp duty is not paid in lieu of the ordinance. Once the document is impounded, the document again is sent to the collector, and the collector has to then deal with that document which is impounded. The penalty, once a document is impounded, is provided in the Stamp Act. I'll go to the sections. The penalty starts from the date the document has been executed. So the risk for that party is twofold. One is that the penalty will start from the day the award has been signed, and 2, it will be impounded and the court may refuse to grant any order, either for execution or for stay, or even hear the petition challenging the award till stamp duty is paid. So these are the risks that the parties will have to take. Therefore, it will be the decision of the party whether to adjudicate and pay that or whether to proceed in the court. Once document is impounded or even it is given for adjudication and stamp duty is not paid, the consequences will have to
How
follow.
long does it take before that process is completed?
Yes.
Inbounding to payment?
That, as I said, there is no fixed time. That
Within
30
30
days is provided that within 30 days they have to adjudicate and give a demand.
Right.
But collector's office takes their own time. And also other reasons are there for.
But on an
The
average
delay
in
or-
Mumbai, how much is the time?
In Mumbai, normally it depends on, I don't want to say it in this public platform, but everybody knows how you can expedite or how you cannot expedite. The reasons are very obvious and known.
No, there is
So,
money is to be paid.
yeah.
Let's start with that. Then it
Then it may take about 6 months also.
Oh my God. Now, my question to you is this, that a party does not immediately proceed to have it adjudicated once it has got the award, and waits to see whether 34 is filed challenging the award. Now, for 34, there is a period of 90 days and another 30 days provided there are valid reasons for doing that. And thereafter, 34, 37, SLP, it happens, and after few years, the award is set aside. In the meantime, because under 34, the party challenging the award will have to pay the stamp duty. So stamp duty would have been paid. Then there is no risk to the successful party because it is then convenient for him to wait. But once 34 has been filed and the document then is paid stamp duty on, then the only risk he will entail is payment of penalty ultimately, not otherwise.
But if the document is impounded by the
Bound to
court
be,
and
it's
sent,
bound to be.
then yes, he will have the risk of penalty.
Okay.
And once the impounded and sent for adjudication, then further proceedings will only come if after demand notice is issued and the amount is not paid, right? Then they may go for prosecution.
So that will be then subject to orders of the court as to who
Yes.
bears the cost of penalty and so on and so forth.
Yes.
I understand. There was one more thing that I wanted to ask you. Suppose in an arbitration, there is a claim and there is a counterclaim. Say, let's say claim is 100 crores, counterclaim is 50 crores. When I go for adjudication, normally the arbitrator, what will do, suppose he's granting 100 crores and granting 50 crores, he will say that the party will pay 50 crores and square up the matter. But when he goes for adjudication, will it so happen that stamp duty will be collected separately for claim and separately for counterclaim? Or will the stamp duty be taken only for the net amount of the award given by the arbitrator?
This will depend on how the award has been drafted and framed and passed.
Generally, they
If
give the
a net
figure.
amount is given, in my view, they will go by the net figure. Because then it will be a direction against only one party to pay.
Right.
The other thing will be set off against maybe the counterclaim will be set off against the claim or the other way around.
Right.
So then it is on the net amount. But if there are two separate awards passed, then there will be two separate awards, and then that would amount to two separate instruments. Then in that case, separate it would have to be taken.
Now, in theory, parties are in dispute. Without going to the court, they decide to appoint the arbitrator. Arbitrator is appointed. Arbitrator gives his award. Without disputing the award, 34 or requiring anybody to take proceedings under 36, the unsuccessful party even pays the award. What happens to payment of stamp duty in such cases where no intervention of the court is required, parties voluntarily obey the award and pay. Would they still have to pay stamp duty on the award?
There we go to the consequences of non-payment of stamp duty on any instrument for that matter.
Okay. So the stamp duty would still be payable irrespective of whether the court is involved, court is
Court
not.
is not involved. Provision is there, so stamp duty is payable. But
Right.
suppose it is not paid and the parties have acted on it. So long as no one bothers, nothing may happen.
Okay.
But once the matter goes to court,
Somewhere,
or
yeah, before any adjudicating.
because the provision for non-payment of stamp duty apart from prosecution is there said,
Yeah.
which if the government comes to know and sends you a notice that you have not paid,
Right.
this may not be likely.
So risk
Somebody
is
will
not
not
worth
come to know.
it. Okay.
But if at all the matter goes to court,
Mhm.
then whether it would be admissible in a question.
That's so therefore your advice would be to pay stamp duty, whether you settle it amicably or whether you.
Stamp duty is payable. So
Right.
to give an effect, particularly if it is for immovable property. Because if the award is with regard to an immovable property,
Right.
then to mutate your name on the property records or whatever,
Right.
there won't be any transfer till it is a registered document and it is a stamp duty paid document.
So if I was to set out the points as takeaways from whatever you have said, in matters where awards are yet to be declared, it is best that the arbitrator or the parties first must tell the arbitrator that, look, please include in your award the quantum of the stamp duty also, as to which party has to bear it. The arbitrator will proceed to sign the award, give it to parties, and it is advisable that the successful party, at least or who wants to enforce the award, goes for adjudication of the stamp duty. Once it is adjudicated, on receiving the demand within 60 days paid, whatever time it takes, so that the danger of any penalty being imposed is gone. Then he has to only wait whether somebody files 34 or does not file, or he himself goes and files 36. In either case, there is no fear of any impounding. The 34, 36 proceedings will go smoothly because already the stamp duty has been paid. So perhaps the wiser course is this. Now I come to the next step. Suppose somebody follows your advice, as you have said, that he applies for adjudication, it is adjudicated, he pays the stamp duty. And at the end of all this journey of 34, 37, SLP, etc., the award is set aside, which means that the stamp duty that he has paid is otherwise gone waste. If he's gone out of pocket, he's lost the award, he's lost the stamp duty also. What is the fate of such a party who has paid, but now finds it was all futile? Is there a relief provided under the stamp act where he can then go to the stamp duty authorities and say that please return my money because that award is not legally valid anymore?
So the Stamp Act under section 47 provides for allowances for refund of stamp duty which is already paid, and where the transactions are afterwards found to be due to any error or mistake and are found to be unfit. Therefore, if the court has come to a conclusion and set aside the award, it amounts to that there is a grave error in the award, there is a mistake in the award, and therefore it is now unfit for being executed.
Okay.
And under that, for that reason, refund you can claim. That look, now the award has become unfit, I cannot execute it. And
That's right. So refund will be full.
refund will be given.
Okay.
And but there is a proviso here that the refund application has to be made. There is a time limit, and that is 1 year from the date of execution. Now, as we know, the courts may not decide these issues of setting aside the order. It may go all the way to Supreme Court. It may
Within
take
1
more
year,
time.
nothing happens.
Yes.
34, 37.
There is no such provision that if the matter is pending in court, then that time has to be excluded from the time of 1 year or anything. But
So would you in that case suggest as a practical course, may not be strictly following the framework of law, that the successful party applies for adjudication? As you said, 6-7 months easily elapse by the time even the notice of demand is issued. Now, within that time, if somebody is challenging the award, has to challenge it under 34. If under 34, then he challenges it and courts says that the stamp duty has not been paid and seeks to impound it, will the fact that adjudication has been applied for will help in saving the penalty part?
penalty definitely, it
It will
says till the demand notice is issued and 60 days thereafter.
So before that happens, if 34 is filed, the fear of penalty will not arise because you have already applied for adjudication. So the right course, I mean, we are just exploring as a practical advice to people or the stakeholders that successful parties should go for adjudication. Within 3 months, you definitely know whether somebody is filing 34 or not. If 34 is filed, at least there is no fear of any penalty being imposed upon him. And take your chances with 34. And if the matters are pending in the court, in any case, stamp duty will have to be paid at some stage without the penalty and subject to the final orders of the court. The parties will either get this cost or will not get this cost. Wonderful.
One more thing I
Yeah.
wanted to add in the refund or
Right,
allowance
right.
for stamp duty. There is another section 52A also, which is also for allowance of duties, and there is no time limit mentioned. But it gives authority to certain officers under the stamp act to consider the application
Is their discretion, not,
at their discretion.
not bound to.
No, they have to in fact see whether the pool is necessary. And the reason there again is the same. Which are spoiled or misused or not required for use.
Okay. So, taking cue from what you said, that if it is executed outside of the state, then this duty will not have to be paid. Now, our neighboring state, Gujarat, has a flat rate like it was in Maharashtra at one time. Suppose parties decide, even when the arbitration has begun, and I believe that is permissible under section 20, because parties can always agree to have a seat of arbitration. It can be anywhere, even if they have earlier agreed that the seat of arbitration may be in Maharashtra, they can agree to have it shifted to Gujarat. Then ordinarily the stamp duty would be what is payable in Gujarat. Pay that stamp duty. Of course, section 34, 37 will all happen in Gujarat. And only at the time of enforcing the award, if you have to come to Maharashtra, then you pay, and for which you have 3 months in hand. So that's another practical solution perhaps, which is possible for people to adopt. So I think essentially, Gautam, I think we are done. So far as anything else would you like to add?
Then we'll answer questions.
That's fine.
Yes,
Now let
there
us
are
see.
questions. So, Selby or Sia, one of you start asking the question. I think some of the questions have already been answered, but I'll start with the first one. What happens in an ex parte award?
In a
Ex parte.
Ex parte award.
situation remain the same, it's an award. Whether it is ex parte,
Right. Whether it's ex parte or even an interim award for that matter, because if it's an interim award, it will be something like a 5-year award.
no change, no change.
The Micro, Small and Medium Enterprises Development Act, Section 18(3) provides for the Micro and Small Facilitation Council to act as an arbitrator if an award passed under an arbitration mandated by a statute. Does these provisions apply to those awards? So
I think
basically,
arbitration. Yes, Mr. Mehta.
Yeah, so again we go to the ordinance and or even in the Article 12, which says that a decision in writing by an arbitrator or umpire on a reference made otherwise than by an order of a court in the course of a suit, being an award made as a result of a written agreement to submit present or future differences to arbitration. It doesn't speak of reference by way of a statute. It says written agreement to submit present or future differences.
So would that be an exclusion?
Yeah,
I would say if it is
you may
an
not.
arbitration by way of a statute, then these words would not be covered.
So supposing like for an MP, they have the JAL boards and there are statutory arbitrations under JAL boards, assuming that there is a similar clause that applies. Then arbitrations before the JAL board which are pursuant to statute and an award passed by JAL board will not be covered within the ambit of this ordinance.
Apparent.
Yes, because whether this ordinance or even earlier, because as I said, the first portion of it has remained the same.
Hmm.
If you see the unamended article also, this portion has remained the same. So they always wanted to, even that 500 rupee stamp paper which were being taken for the purpose of passing an award by any arbitrator, had the same words. And therefore they always meant that this has to be an award which is from a arbitration proceedings arising out of a reference by virtue of an agreement between the parties, a written agreement between the parties. That
Yes.
seems to be the.
So basically, when you say that written agreement, you are referring to Section 7 of the Arbitration Act and excluding statutory arbitrations under some other provision of law. Would I be correct in saying that?
Yes, because the way it is worded here, my interpretation would be like that.
Very well.
It clearly excludes any reference from a suit by a court, and also clearly excludes any award which directs any partition. So there are these two specific exclusions. But when they say reference award as a result of a written agreement to submit present or future differences to arbitration, it would mean a written agreement inter vivos between parties and not arbitration by a statute.
Okay. Now, what happens if the award is set aside? I think you've answered it. Have you? Or if
Refund.
Refund of stamp duty. Yeah. Then the next question is what happens to award that has nil value? That is award dismissing a claim and the party has to execute it because it deals with any liability. That's the question, wording of the question. So if it's a nil award,
Nothing.
The nil award, then it is nothing because then
that's right. So won't it be
the amount.
It says up to 50 lakhs will include zero.
So the words here are where the amount granted in the award.
That's right.
So unless there is an amount granted, there
Has
is
to be
nothing
more
there.
than zero, I suppose.
So what you are saying is it has nothing to do with the claim or value of the claim. It has only to do with what is there contained in the final award that is passed, the award passed by the arbitral tribunal. Excellent. Now, the next question is if an arbitration award is passed at the decided place of the party, the state of Tamil Nadu, and the favorable and the stamp duty applicable in that state has been paid, does the party holding this award need to pay stamp duty to execute the award against the party in a different state, such as Maharashtra? I think you already answered it. That
No, I have not answered. This question is very specific. What he means is that if a duty is already paid in Tamil Nadu,
Correct.
and then the award is brought into the state of Maharashtra, then again stamp duty is to be paid or not. Here the provision in 18 where it is execution out of state says that the difference has to then be paid. If the stamp
Correct.
duty is more in Maharashtra, then you have to pay the difference.
Okay. So the differential
provision-
amount is only to be paid.
Yes, yes.
Okay. The next question is what stand to take on stamp duty payment obligation if anti-arbitration injunction issued 30, 60 days after arbitration award, especially in foreign seated arbitration, example, emergency arbitration award by CA. Can I
Sorry, can you?
answer this?
Please go
Yes.
ahead.
Mhm. See, irrespective, let us understand, Abhishek, the answer is very simple. That in Maharashtra or wherever the stamp duty is payable on the arbitral award, if the arbitral award is executed out of Maharashtra and brought in Maharashtra, then it will be susceptible to stamp duty at Maharashtra rates. If there is a deficit, it will one will have to pay the deficit component as per the Maharashtra. So whether it is a foreign award which is coming in for execution or it is any other award, it doesn't the ordinance doesn't say that where arbitral awards are only made in Maharashtra. It says that when an arbitral award is passed. Okay, I hope I'm clear. If there's a question, follow-up question, please ask. Ashok Dhanuka, if a person files suit for specific performance and has already paid stamp duty on AFS, what is AFS? And
Agreement for sale. AFS is agreement for sale.
No, I'm familiar, but I wanted it to be clarified so that those who don't know understand. And he succeeds in the arbitration, whether he's required to pay stamp duty on arbitration or there will be a rebate. So stamp duty
Okay.
paid on an agreement for sale, not
Yes.
performed, goes to arbitration,
Yeah.
arbitration award.
Okay, may I answer that now?
Please go ahead.
Yeah, so now, correct, agreement for sale, the amount is already paid. But that is a separate document and an award is a separate document. There are two separate articles for that. Agreement is stamped under either Article 5 or under Article 25 for a sale of any movable property. And as far as award is concerned, it is under Article 12. Both are treated as separate instruments. Now, there is an element of double stamp duty here, definitely. They have not considered this. It is a very vague and ambiguous ordinance that has been brought. They have not considered a lot of things. 100% this amounts to double stamp duty. As far as other provisions are concerned, where suppose there is an agreement for sale and then ultimately a conveyance is executed, then they have provided for rebate. Similarly, in case of a development agreement, if you have paid stamp duty and then permanent alternate accommodation agreements are made, again there is no stamp duty on those agreements. So there are such provisions made in the Stamp Act. But for this particular award, there is no specific reference or provision given that if stamp duty is already paid, say on agreement for sale, or maybe it is to be paid on a conveyance under the award, then whether any rebate or any concession or any deduction has to be given or not, that is not specified. So in my view, it will amount to double payment of double stamp duty. While on the topic, I would also like to point out one more thing, that even in the schedule for payment or under the movable property, the schedule is very, very different from the other schedules. As under the Court Fees Act, for example, they have said ad valorem, but if you see in B, the first one says where the amount granted in the award does not exceed 50 lakhs, then it is 0.75% of the amount granted in the award. Then when you come to 2, it says where the amount granted in the award exceeds rupees 50 lakhs but does not exceed rupees 5 crores. So award amount may exceed 50 lakhs. Suppose say it is 60 lakhs. It is exceeding 50 lakhs. Then in that case, 37,500 plus 0.5% of the amount granted. So it is not 37,500 plus 0.5% of the amount over and above 50 lakhs. It is on the entire amount granted. So there also again they are charging double because 37,500 is 0.75 of 50 lakhs. So what they were supposed to do is that they should have mentioned here, in my view, when it exceeds 50 lakhs, then it should be 37,500 plus 0.5% of the amount over and above 50 lakhs up to 5 crores. And same way in 3, where the amount granted in the award exceeds rupees 5 crores. Then they said 2,62,500 rupees, which would be actually 0.5% of the amount under 2 on 5 crores. And then plus 0.25% of the amount granted again. So it is again on the total. This seems to be a flaw in drafting this ordinance.
Yeah.
It should say there this 0.25% of the amount over and above 5 crores, which is how ad valorem is in the Court Fees Act. So there is a double stamp duty here also.
May I suggest that there is something that I've observed, and somebody can check it out, that instead of looking at the stamp act for charging stamp duty on arbitral awards, it seems that they have virtually picked up the language more or less from the 4th schedule, where the fee structure for arbitration and the language is quite similar. That if you see the right column where the amounts are mentioned in the 4th schedule, you might find that this is more or less in a similar, because there the percentage varies, the right column about model fee. So anyway, but my next question to both of y'all will be this.
No, I have seen that 4th schedule. In fact, it says like that only. Above 5 lakhs up to 20 lakhs, 45,000 plus 3.5% of the claim amount over and above 5 lakhs. It says
Correct.
so. In fact, even schedule 4 is like that. But here it is like paying that amount on the original value and then again paying on the total amount. So you are paying.
I'm glad you clarified this. Now, one question which I have is that, ultimately, if the award is final and there is no challenge, then it is to be enforced in same manner as if it were a decree of the court under section 36(1) of the ACA. But then the first question I have on this is, how do you, when a party comes to you for recourse, judicial recourse, because somebody has not done something that was required, so to get justice, and then when you get something in your favor, to pay stamp duty on it is a little unfair, because our decree is susceptible, except for immovable properties, otherwise susceptible to stamp duty.
Decrees are susceptible to stamp duty only if it is for immovable property. It is not. It is actually susceptible provided you go and register a decree. If it is a decree for say specific performance and you go and register a decree, then it is to be registered under section 17. It is compulsory to register such a decree for transfer. Then in such a case, stamp duty would be payable on that decree. And that you find under the definition of conveyance in the Stamp Act, section 2G. And if you see section 2G of the Stamp Act, it includes every decree or final order of any civil court.
Hmm.
Now, conveyance also, the definition says conveyance includes every decree or final order of any civil court, and then it says by which property, whether movable or immovable, or any estate or interest in any property is transferred to any other person, inter vivos, and which is not otherwise specifically provided by Schedule 1. So, therefore, if a court order is passed and a decree is passed, whether for movable or immovable, stamp duty is attracted on that. Because it's a monetary claim, people don't pay that. But when a decree is registered in case of an immovable property, stamp duty is paid. But definitely what is done is that instead of charging court fees for filing an arbitration case, because there is no court fees in arbitrations, they have sought to now put it on the award. It seems like that.
Okay. Okay, next question is, would it be advisable for parties to file a suit despite an arbitration clause and submit to arbitration? So whether this is 89 or 8 would be the question. No?
No, even if it is under 89, the proper suit is filed and you are referred to arbitration. Now, under today, that goes under Mediation Act to 2023. And then what is passed is a conciliation order, settlement order, which is still subject to stamp duty like any other court decree. So I don't think that one can avoid these ad valorem stamp duties by resorting to those, just because that is an exclusion to Article 12 here. So that's my view.
Okay. What happens if both parties mutually decide to accept the award, dispensing the formality of enforcement? Firstly, though, in my humble opinion, in India it would be
We
a
have
very
answered.
This
And
was
we have already
covered.
answered that. We have already answered that. I did ask that question to Mr. Modi, and he said, no, it is advisable to pay stamp duty. Unless, you get caught in, you never get caught before any authority or anything. So,
So
stamp
for
duty is payable.
correct.
This is, I would put it this way, what we just discussed, that if it is an order of the court, whether movable or immovable, if there is some transfer of movable property also, stamp duty is payable. But if that movable property is just handed over pursuant to a decree of the court, you don't pay any stamp duty on that.
Okay.
So
So
then-
this next question is, so for arbitral award under MSMED Act is exempted from stamp duty. Is that understanding right? If yes, under which provision? I don't know, Mr. Ray, this is something that will require to be studied, and I think they will give you an answer subsequently if you can contact the IMC Secretariat. Abhishek has a follow-up question. Yes, please. The question is more on conflict arising due to anti-arbitration injunction order issued by a court in India, but it came only after 30/60 days of emergency arbitration award already given by foreign seated arbitration. Can I just clarify, ask for a clarification, Abhishek? Correct me if I'm wrong, that emergency provisions under SEAC and now sought to be brought in even into India are just in the nature of Section 17 or interim proceedings. I don't think that it would constitute an award because there is no final adjudication on any point by the arbitral tribunal. But if you still wish to clarify, I will request the IMC people to unmute you so you can ask the question directly. In the meanwhile, is it true that the AFS and award are treated as different, and therefore a question arises under Section 4 of the Stamp Act whether award can be considered as subsequent instrument and AFS as principal document. What is your view?
No, I would not say that it is a subsequent instrument. I would say award is an order passed or by the adjudicating authority deciding a dispute between the two parties. That cannot be treated as an instrument or a inter vivos document between two parties. Maybe a settlement agreement file could be treated, but not this,
All right.
in my view.
So
In
there
my
are-
view, it can't be, but this can be taken to the court saying that this is the way double duty is being charged, so that benefit should be given and this should be treated as a second instrument under section 4.
So I'm glad you made that point, Nilesh. I'm wondering whether Bombay Bar Association, your Society of Arbitrators, and the Advocates Association are planning to take up this matter, because as we saw during this entire conference of 1.5 hours, this webinar, it's more murkier, more complex than one thinks it is. It is not, as I said at the outset, not a simple thing of payment of stamp duty under the award, but raises far too many questions than it answers. Any further questions anybody has? Then otherwise we would like to conclude this webinar today. Shikhil, are you there? Can you unmute yourself, or who's giving the vote of thanks?
Sir, Shikhil, sir.
Shikhil, please, Shikhil, can you unmute yourself? Shikhil is the head of the webinar committee and he's a senior advocate, Supreme Court Delhi. He's a part of our arbitration committee. Shikhil, over to you.
Thank you, Gautam bhai. On behalf of the IMC and its arbitration committee, of which Mr. Shinde is one of the pillars, I'm very pleased to say that this was an excellent session, and you were very generous with tips which would otherwise be very chargeable by the hour. So you were very, very generous in giving practical tips to our audience, and we very much appreciate that. And I would like to extend our deepest gratitude to both of you for taking out the time and addressing us on this issue. Also, I'd like to thank Gautam bhai for picking up this topic. As I understand this, and after hearing you, this is a topic which will have wide ramifications for all stakeholders in Bombay. So a very timely topic, and something which I think all of us will be grappling with in the near future. So thank you, Gautam bhai, for your leadership and continuous prodding for taking up topics which are of interest to arbitration practitioners. My other vote of thanks is for Tom and Sneha, who are members of the organizing committee and who've done all the background research, not only for this webinar, but for the previous ones as well, and who share their input with our speakers and co-speakers. And last but not the least, the IMC team, Sia and Prajat, and our technology team for putting this together. Just two housekeeping things before we part for the year. I think there is lots to look forward to. As part of the arbitration committee, I think it's a very proud feeling for me to say that in the last, I think, 6 months or so, we've had 4 or 5 very successful webinars. So all in all, a very good year for us. But very excited and looking forward to our 7-day marquee course, which, as all of you know, is probably in its 16th year now, I think, and
18th.
was envisioned by 18th year now. So 18th year of the IMC 7-day course, which, as you know, is conducted by former judges of the Supreme Court, High Court, retired sitting, and senior advocates and other advocates from Bombay and Delhi and other parts. So that is going to be held in February or March. So please stay tuned in for the dates for that 7-day course. And just as a bonus, parting bonus for people who've not been able to attend these 4 or 5 webinars that we've had, the committees decided to put all these on YouTube for you to be able to view them, for all those who have missed. And Happy New Year to everyone.
Thank you.
Thank you
so much.
Wish you the same.
Wishing you the same.
Wishing